Hi everyone, my name is Kip Cordell and this is my presentation for ALTC803, Module 3, Intersecting Foundations of Rights, Religious Freedoms is the topic that I chose for my presentation, Religious Freedoms in the Classroom. So the question that I will pose at the start of my presentation is the recitation of a non-denominational prayer in school an infringement on the Establishment Clause of the First Amendment? So, some background on this. There's an old saying, as long as there are tests, there will be prayers in schools. Now, normally this would be kind of a joke on referencing students praying for straight A's or praying to do well on tests. But we are going to specifically be looking at the Supreme Court case Engel versus Vitale in 1962. In New York State is where the case took place. There was a daily reading of a prayer in the public school systems. The prayer was non-denominational, so basically it did not apply to a certain religion or class. Ultimately, the Supreme Court ruled 6-1 that this was an unconstitutional violation of the Establishment Clause of the First Amendment. Now, for us to kind of know what that means, the Establishment Clause prohibits the government from establishing a religion. So, there is a test to actually kind of govern or determine whether something violates the Establishment Clause. And this was called the Lemon Test. It was used by the Supreme Court and put forth by them in the case Lemon versus Kurtzman. And it is composed of 3 parts. So, the government can only assist religion if the following 3 criteria are met. The primary purpose of the assistance is secular. The assistance must neither promote nor inhibit religion. And there is no excessive entanglement between church and state. Now, one important factor that I want to kind of point out here is sort of the vague wording in that last prong there. Excessive. Excessive can be relative. It can be different to different people. So there, just the wording itself that they use is kind of vague and that allows it to be interpreted in multiple different ways. So some more background. Here is the actual prayer that was recited in New York public schools. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. This prayer was known as the Regent's Prayer. The First Amendment says Congress shall make no law respecting an establishment of religion. The question becomes, with this Supreme Court ruling that it violated the Establishment Clause, which of those 3 prongs that we talked about did it violate? So, in an argument dissenting from the ruling, Justice Potter Stewart wrote in his dissension, with all respect, I think the court has misapplied a great constitutional principle. I cannot see how an official religion is established by letting those who want to say a prayer say it. On the contrary, I think that to deny the wish of these school children to join in reciting this prayer is to deny them the opportunity of sharing in the spiritual heritage of our nation. So you could say that prayer, it's not denominational, and you could say it's not the New York public schools. It's not an attempt by them to establish a official religion. Nowhere did I see, and this is just me talking here, nowhere did I see in the readings that I was able to find online that they made the students say that prayer. So with the students not necessarily being required to say the prayer, my mind initially jumped to it being very similar to how we treat the Pledge of Allegiance now. If a student didn't want to say the Pledge of Allegiance, maybe didn't want to put their hand over their heart as they say it, take off their hat, students now really don't get in trouble for that. We see it as their option whether they want to participate or not. So I see these two very similarly. So, since students weren't forced to say this, how could one argue that the New York public schools were trying to establish something when they weren't requiring it? So, if we look more closely at the Lemon test some more, the first prong was that it can't be secular. So, by non-denominational, what that means and what secular means is it does not belong to a particular religion. So, it doesn't violate number one. Number two, assistants can't inhibit or promote religion. By not being allowed to say this prayer, you could say that it's inhibiting. So if students are allowed not to say it, is it really promoting it? So by saying that, you could say it really doesn't violate number two. Number three, no excessive entanglement between church and state. What constitutes excessive? Without a clear definition on number three, how can we tell if it's violating it? With all of this being said, could you explicitly point to one of those three prongs and say that it is for sure being violated? With all three of those, I can see where somebody could make the argument it is, but I personally don't see where you can definitively point to one of those and say, yes, that's the one that it violates. So, arguments in favor of the ruling. Justice Hugo Black wrote, "We think that by using its public school system to encourage recitation of the Regent's Prayer, the state of New York has adopted a practice wholly inconsistent with the Establishment Clause. It is no part of the business of government to compose official prayers for any group of the American people to recite as a part of a religious program carried on by the government." So, a couple things in that statement by Justice Black that I'm going to dissect a little bit. So from his comments, I think the wording is critical here. He says, in part, it is no part of the business of government to compose official prayers for any group of the American people. Now, is he saying that the state of New York and the New York public school system actually wrote that prayer? I couldn't find anything saying that they actually composed that prayer, but if they did, then I do think Justice Black has a point, that the government really doesn't have any, it's not their business to actually compose things. Secondly, it is argued that it was ruled this way because the prayer was done in a public manner. So in another article I saw that I have referenced here at the end of my presentation, it says that because it was done in a public manner is kind of where it crossed the line. And I'll talk a little bit more about that later. The Bill of Rights Institute states that people argue this ruling outlawed prayers in school, but that is not the case. They argue this ruling only prohibited schools from writing or giving a specific prayer and having all students recite it. So that's where they draw the line there. If a student says a prayer quietly to themselves, if students meet as a group somewhere and pray at the school, that's fine, but they say once it's required, said in public, and they are told what to say, is where it comes into issue. So some of my lessons learned from the readings, from all of our readings this week, the courts actually seem to rule fairly consistently, and I did actually appreciate that from reading multiple of their rulings. And if a decision came down to constitutional rights and whether they were being violated or not, typically a couple things I saw were consistently cited. And this was school or public safety. For instance, in Tinker versus Des Moines, they ruled in favor of the students wearing the armbands in protest of the Vietnam War. The court agreed with the students and struck down the ban, saying that the school has to prove that the conduct or speech materially and substantially interferes with school operations in order to justify the ban. So initially, the students were suspended from school until they agreed not to wear the armband. But the courts came in and said what they're doing does not materially or substantially interfere with school operations, and that they could not justify the ban. Another reason that was cited for a lot of the rulings that were made was equity. You could say Brown versus the Board of Education was maybe the most noticeable and important Supreme Court cases. Maybe not necessarily with education, but you could maybe even say ever. It's up there, maybe the top 2 or 3 even. When it comes to so when I looked at this case, when you look at it, there aren't any school or public safety issues, and there's really no equity issues as long as they weren't forced to say it. If they were forced to say it, then I see where there would be an issue. If somebody doesn't believe in God or is not a Christian, they should not be forced to say something that they don't want to. But what I was able to find did not reference or say if they were forced to say this or not. When it comes to freedom of speech, while I believe the courts do a good job of making decisions based on precedent and law, which I really do think they do, there are, in a lot of the rulings I read, they do a great job of citing why they're ruling the way they are. A lot of their rulings, their reasoning was solid. So I really do think in general that the Supreme Court does a great job ruling. However, they are still human. I believe vague language in certain laws or statutes can lend help to a justice if they're trying to find a way or justify a way to legally follow their personal beliefs in a ruling. I will point back earlier in the presentation, we talked about the term excessive, a very vague general word. They don't point with that term exactly what that means or exactly what would constitute that. So one of those vague things that I'm talking about there. West Virginia versus Barnett, this was 1943. The court ruled that it is unconstitutional to require students to salute the American flag. The First Amendment not only protects freedom of expression, but also freedom from expression. So I'm going to go back to some references to comparing this to reciting the Pledge of Allegiance. And I reference that because I do feel it's very similar in context to Engel versus Vitale. When do you decide to rule for or from expression? This is why I feel the nominations of justices right now, it's such an important political event. Both sides know, with those being lifetime appointments, that if they can get those seats filled by a justice who they can see from their past might lean left or lean right, they know they have somebody like that on the court for the rest of that justice's life. While I believe judges are honest and admirable, their personal or political leanings can dictate how a ruling goes in toss-up cases. So exactly when would you decide to vote for or from freedom of expression? Ultimately, in regards to this case, I understand why they chose to vote the way they did. I think the school would have been better to give that time where they said the prayer out loud. Maybe they could have, given that time to pray quietly for, a minute or two, or do whatever they liked quietly at the start of the day instead of having it be a group prayer effort, or just find another way to go about it. But I think it was the fact that the prayer was said as a group and they were giving the students what to say is what swayed that ruling. And one of the most important things, I'll go back and just say one more time, if New York State or the public school system composed that prayer, then I definitely think that the ruling has more to stand on if the public school system or state, as an arm of the government, actually composed that prayer. Here are my references. Students' Rights in School Supreme Court Decisions on CourseHero.com. 10 important Supreme Court cases about education on the National Constitution Center. United States Courts, uscourts.gov. Bill of Rights Institute. They actually had 2 different pages. They're each referenced separately there. 2 different pages on the Bill of Rights Institute that I pulled from. So thank you, everybody. Thanks for taking the time to watch my presentation. Bye.